Good morning, Judge.
Good morning.
Morning, Brett.
Good morning, Kit.
Good morning, Your Honor. Mr. DeHoff is here in my office along with his family. I know you can't see them, but they're sitting here as well.
All right. We are going to go on the record in state of Kansas versus Joseph DeHoff. It is 22 CR 386. The state appears by and through Mr. Sweeney. Mr. DeHoff is appearing by Zoom in Mr. Watts's office. Of course, Mr. Watts appears. We are scheduled for sentencing today. There's one count of possession with intent to distribute. It is a level 4 drug felony. It is a registration offense, which we've already gone over at the time of the plea. It should already be registered. It is a border box. It is not a mandatory Senate bill case. It requires findings by the court since it's a level 4. However, it does not appear he has any prior criminal history, including any felony history. He has a few misdemeanors for sure. One in 2009, a couple in 2018, and a disorderly conduct in 2020. But he has no prior felonies. He is required to register for 15 years. What are the recommendations by the state as it relates to imposition of sentence in this case? And I'll ask you first, do you have any objection to criminal history score of I, Mr. Sweeney?
No objection from the state, Your Honor.
I assume you don't either, Mr. Watts.
We do not, Your Honor.
All right, recommendations, please.
Your Honor, the state's recommending the mid-box, 15 months in Department of Corrections. The defendant would be eligible for 20% maximum good time percentage. He would have a 24-month post-release supervision duration, and he has 7 days of jail time credit. As the court previously noted, it's a border box, and with court finding, the court can place him on community corrections probation with Senate bill treatment. If the court does that, and I have the pre-sentencing drug and alcohol evaluation. So if the court does that, I've taken a look at that. All of the proposed conditions that are listed within the PSI appear to be appropriate, including specifically, obviously, the Senate Bill 123 treatment, if probation is granted by the court. If probation is granted by the court, I similarly believe that all of the conditions that are listed in there as standard appear to be appropriate for Mr. DeHoff. As it relates to costs and fees, Your Honor, the state's not requesting a fine, and that's pursuant to plea agreement. However, there was a KBI laboratory report that was completed. The state's seeking $400 in restitution for that report. Mr. DeHoff is a first-time Kansas felon, so the state's seeking $200 in restitution for the DNA database fee. Court costs, of course, supervision fees, correction fees if probation is ordered, Senate Bill 123 fees, attorneys, bids fees. Your Honor, I think that's really about it. Thank you.
All right, Mr. Watts.
Thank you, Your Honor. Likewise with the state, we would join the recommendation of 15 months in the Department of Corrections. We will be asking this court to make that as an underlying sentence. There would be 24 months post-release should that be necessary, and a probation duration. We will ask for up to 18 months. Because we are asking the court to make that court finding. Mr. DeHoff has an eye on the grid. Obviously, he has very little criminal history in this matter. And consistent with my recommendations, and I know Your Honor hasn't probably seen it. I can forward it to Mr. Sweeney, and I don't know if I have your email in my.
Your Honor, that is correct. So the state would go ahead and recommend that. I see that now in my own notes. The state would go ahead and recommend the 1 month off. So 14 months as opposed to 15 months, the mitigated box pursuant to plea.
And Judge, we'd likewise join that. I will. I'm asking the court to make findings and place him on probation. He is currently in treatment with, let me pull it up here again. I had it a moment ago. Where'd it go? What happens to these silly computers? I can't find stuff. There it is. He is currently in placement with addiction recovery in Augusta. I have before me a letter from Diane Briggs dated May 18 that he is entered treatment there. He entered there, in fact, in February, and is still in treatment with Addiction Recovery Center. We would ask that the court make the finding called for in KSA 2168-24 and make a finding that placing him in treatment is not a threat to public safety. I think that's evidenced by his lack of prior criminal history, and place him on what amounts to a Senate Bill 123 treatment program. He is already in a treatment program as we speak, and I know Addiction Recovery is Senate Bill approved. We work with them on a number of cases. We're asking the court to make those findings, place him on probation with the Senate Bill 123. As Your Honor noted, this is a registration case. He is already registering with the county sheriffs. As I informed my client, there is a new statute which will let him get off that registration after 5 years. If he meets certain conditions. That's relatively new within the last year or so. And I think Mr. DeHoff is the first client I've had that will really in a position to take advantage of that. And I'm urging him to do so.
I can't remember if this is a crime from October of 2022. I'm not sure if they've decided whether the date of sentencing matters or the date of the crime in terms of eligibility for that petition.
I don't think it, Judge, I'll have to read the statute again, Judge, but I don't think the statute mentions anything about the date of the crime and whether or not that's only crimes after a certain date are applicable. I'll have to go read the statute again. It's been a month or two since I've read it. As I said, a previous client actually brought it to my attention. I wasn't even aware that it existed. She was unable to take advantage of it. Mr. DeHoff, I think, will be in a position to take advantage of it. I think in the requirements. And I'm confident he will do so, Your Honor. As I said, he went in, began this treatment program in February and is still in that treatment program. So I think he is primed for the court to make those findings, and we're asking the court to do so.
All right, Mr. DeHoff, is there anything you'd like to say before I impose your sentence in this matter?
No, ma'am.
All right, Mr. DeHoff, you have a couple of things that are your saving grace. One, that you entered into treatment and have been in treatment prior to today. Two, since this is a distribution charge, initially a level 1, now a level 4, the fact that you have a high probability of addiction indicates that your possession is probably related to your use rather than profitability or racketeer, running any kind of enterprise for drug-related gains financially. So those things, in my view, are sufficient for me to believe that Senate bill treatment, and if you're successful with that whole treatment regimen, which generally is over at least an 18-month period to fully complete, that you are not a threat, a public threat that requires immediate incarceration. I do think you're even though you have misdemeanors, the type of misdemeanors you have actually be a public threat if you're using. If you're not using, then I think that it's a better decision to order you to complete treatment and rehabilitate you as opposed to incarceration. I don't see you as a grave public threat to anyone as long as you're in treatment and being accountable. That includes an underlying sentence of 15 months with the Department of Corrections, no fine, and court costs. Community corrections for up to 18 months or standard 18 months with standard conditions. Complete your Senate bill treatment recommendations. The court made the findings. The court will order post-release of 24 months. That means that if you begin using again, or you commit a new offense, or you violate your registration requirements, and the court revokes your probation and orders you to serve your 15-month sentence, then you would have 2 years of parole thereafter, and the opportunity to earn 20% good time credit while in the Department of Corrections. Those things are ordered today. They do not come into play as long as you successfully complete probation and your treatment requirements. You are entitled to 7 days of jail credit. You are ordered not to violate the law and continue to properly register, as we've gone over previously. I'm sure if you have any questions, Community Corrections will talk to you about any registration issues that you may have, or Mr. Watts can counsel you in that regard. There's a $400 lab fee. There's a $100 bids fee. There is court costs. I did not impose a fine because it wasn't recommended to me. I am going to ask that you repay $650 in attorney's fees in this matter. I assume that you're capable of working.
Yes, ma'am.
Okay. And the Senate bill treatment fee, I think, is $300. That's pretty cheap for a treatment program. You'll have up to 18 months, and they can extend it another 6 months if you need to get the case paid off. So basically, once the supervision fees and all of the legislative assessments, including the KBI restitution, et cetera, are calculated, you'll get a total. Break that down in 18 months, and that's what you should be making every effort to pay monthly. Keep in mind, if you extend your supervision fees because you haven't paid your case, or extend your supervision by agreement because you haven't paid off your case, you continue to subject yourself to the possibility of serving that underlying prison time. So the sooner that you accomplish things, the better. The sooner you get off and get successfully discharged from community corrections, the better. And you can move on with your life. You have 14 days to appeal this decision. It's possible 5 years after you're off, you may expunge. I doubt you'll be able to expunge the case until you're allowed to be terminated from registration. I really can't tell you how that's all going to fall into place until we kind of see some interpretation of the statute and who qualifies and who doesn't. Substantive legal changes are not retroactive. Procedural matters are generally retroactive, and I'm not sure quite where you fall. But you aren't going to get to that point anyway until you successfully finished your probation. So after you're off probation in a couple years, certainly within 3 years, I would start visiting with an attorney about the current state of the law and what your options are, and seriously consider expungement. Since this is your only felony, it's often helpful if you want to go to work for Raytheon or Textron or Spirit or wherever, that you not have to put down that you've been convicted of a felony. So that will help your job prospects. You're very low on the criminal history score. You're the lowest classification of I. I have great hope that you've learned from this and that you'll figure out how to conquer your substance abuse issues that are pretty apparent in your drug and alcohol evaluation in terms of your usage. It always amazes me that when I have folks in front of me on drug cases, in most cases, frankly, if they have an addiction history or substance abuse history, that it starts when they're 13 and 14. I find that to be quite sad and frankly, very scary for most folks raising kids. And that, that's what your history is. You don't have a psychiatric history, but you certainly have a longstanding drug and alcohol history and usage. I do note, though, that you've suffered from some anxiety and depression. Share that with your counselor. If there's some medications that can assist you that aren't narcotics, that are addictive, that might make you more successful if you're on, like, say, antidepressants. But this is something that you need to take charge of and overcome. And the time is now. There's no better time than now for you, okay? I need you to report today to Ms. Stanfield to begin your community corrections. I'm not going to impose any additional jail time. Is there anything, no firearms, no dangerous weapons? She'll go over all your conditions. If you want me to, I can. But in more detail, you'll have a supervision agreement that you initial each and every requirement, and it's a time for you to ask questions and clarify any confusion or concerns that you may have. No possession or consumption of alcohol or illegal drugs, random breath, blood, and UAs as necessary and reasonable. I'm going to waive community service because I want you to obtain or maintain employment. They need to know where you're living, working, ways to contact you by way of address and phone number at all times. Registration pursuant to the offender registration requirements. I did miss the DNA fee additionally that's assessed to you in the amount of $200. Let me ask this, Mr. Watts, if you calculated your time on this case, do you know what your fees would be at the state allotted rate?
Oh, I have no idea, Judge. I'd have to go back and calculate it all off the top of my head. I have no idea what it would be.
Well, I think reduce the attorney's fee to $450.
It was
plus
billed.
the $100 because you additionally have a $200 DNA fee.
It was billed to bids at $2,400.
$2,400?
Yes.
Oh, well,
Did I understand correctly that you previously ordered a bids fee plus $600 in attorney's fees? Is that correct?
$650.
$650.
I think I'll split it in half. Let's go $550 for attorneys. $100 for bids. That makes it $650 total. And then the $200 DNA, $400 lab fee, supervision fees, $300 Senate bill fees. I think you're certainly looking at $2,000.
Pretty close. Yeah.
DeHoff. But you know what? I find that if people aren't drinking or drugging and they can get themselves off of tobacco or any other triggers, that they have more money than what they certainly had when they were using. Even $2,000 is $111.11 approximately a month that you would need to pay to have your case paid off in 18 months. So I always tell folks, I don't like to saddle people who are really trying to recover with a lot of financial that adds stress or can sometimes just be an excuse to fail for some people. I don't like to do that, but at the same time, the system has to be replenished to some degree. In other words, Mr. Watts has to get paid. These programs that are provided to you at a minimal cost are very expensive for the state. And I do think it is part of your program. At the end of the day, though, I always tell folks, if you've done everything right, but you're short of some money, you can petition the court. There are some things that I can waive or reduce. There's some things I cannot. I cannot reduce court costs or DNA fee or KBI fee, but I could perhaps reduce the attorney's fees. I do think this is something, though, that you can manage. And my expectation is that you will with hard work and dedication. So I do wish you well. Hope that I don't see you again with any problems and that you're successful from here on out. Is there anything further?
No, Your Honor.
No, ma'am. Thank you.
All right, thank you. We are adjourned.